What happened to her previous security deposit? You are the one that is responsible for the holding. So where's her security deposit? You need to go to the previous owner and find out where her money is. You and the previous landlord are end up getting sued. You're saying that complaint under penalty of perjury. I don't think that any of this is true. I'd suggest you go get an attorney.
This landlord is the poster child for many of the things landlord-tenant laws seek to cure and prevent. He bought a place and showed up at the tenant's door the same day to demand a $400 a month rent hike, payable immediately. That's illegal in almost every state. He also demanded the tenant pay a new $2,400 security deposit. That's also illegal in almost every state. And then when the tenant told him to get stuffed, he sued her, falsely claiming rent that isn't owed. That's definitely illegal in every state. Making matters worse, he has no idea where her existing security deposit is, and he's about to find out just how badly that exposes him in Judge Simpson's court. Let's roll this.
David Sawolski versus Lisa Laro. Lisa Laro. And what about Maria?
She's there.
Okay. Your name, sir?
David Allen Sawolski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is you did file it?
I wanted, sorry. I wanted a 1.5 month, $2,400 security deposit. And now she owes $3,200 in back rent because what happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so for her to stay there, I would want $1,600 per month. But that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it, and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were going to charge $1,600 for October?
Yes, sir. If she paid
then
it,
let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
We had no agreement.
Your Honor, he came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
did you tell her that?
24
No,
hours
sir.
to think about it, and I called him back and said, I agree.
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, I for her to stay there, I wanted.
No.
Okay.
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
Yes, sir.
And in that complaint,
Yep.
you basically indicated that, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true. And
I originally offered her, sir, $1,200 if she paid me that same day.
okay. Your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties, and assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent. Yet you filed a complaint that says that the rental rate is $1,600. Frankly, sir, that's false.
Okay.
Then you don't say you say no rent is due, right?
Which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that. I'm sorry.
Then, so if as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one, that's why I feel.
Well, hold on, just hold on, ma'am, just
What
take
I,
a breath, please. All right. How much did you pay as a security deposit?
It was 2,400.
Thank you. So if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, I'll put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was
And-
I'm sorry.
And he told me he had no
I don't-
security deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. That security deposit that is she previously paid, and any security deposit the tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages.
Okay.
So that's where we are. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third
Yes, sir.
on my say so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the $1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit.
Yes, sir. I wanted the 1.5 month security deposit plus the $1,600
You
a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her a notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my pre.
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof. But I don't see anything in the beginning of this that you did that's right. At all. Have you asked the previous landlord if he has a security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are end up getting sued. So my question becomes, what do you want to do with this case?
Well, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yeah.
So somebody needs to find it.
Okay. So I would need to contact the previous owner and see what.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
Okay. I'll contact.
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
Well, I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights.
Well, because if she put
sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances. Not sure if that was any of your business, but that okay. You took the place, didn't get her security deposit, asked her for another security deposit, and then try to increase her rent by a third. So here's what I'm going to do. Okay. I'm going to adjourn this out 1 week. You think about it. You try to figure out. I'd suggest you go get an attorney. Because if she turns around and files a claim, you're going to have a heck of a time. I'm just going to be honest with you. But that's going to be your call. I am not, because it's not in her interest. She's unrepresented by counsel. I'm not going to, and she's appeared. While you're moving to dismiss, I'm not granting your motion to dismiss at this time so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you having a conversation, provided you want to approach her as your equal. Thank you.
Thank you, sir.
Have a good day, ma'am.
1 p.m. November 7th.
1 p.m. November 7th.
Judge Simpson was trying to tell the tenant something there. If she got the hint, she'll see she could sue the landlord for $7,200 and win. I have 2 more cases for you, so don't go anywhere just yet. The first is a tenant who's been paying rent into escrow because her landlord makes her drive her trash an hour to her parents to toss it. The last case is an interesting fellow who rolls in hot and rolls out even hotter. Let's roll those.
Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Cross Street.
And Ms. Schumacher?
Hannah Schumacher.
All right, very good. Okay, where are we on this case?
Your Honor, this is a non-payment of rent case. We did not ask for a money judgment. Currently, rent is owed in the amount of $2,425 through the end of October. Court costs are $164.40. Total amount to retain, $2,589.40.
Right. Ms. Schumacher, how are you intending on getting that paid?
Your Honor, I have my full rent amount placed in escrow until the landlord can provide, uphold their lease obligation of sanitary and accessible trash as per the lease.
So when you say trash, I guess I'm not clear what you're referring to, ma'am.
Yeah, so section 1.7 of my lease states that the landlord shall furnish the tenant the following utilities: water and trash. I do not have a sanitary and accessible trash bin, which is why I have placed my rent into escrow.
So there are no trash bins?
No, Your Honor.
Okay. All right. What I'll need you to do, ma'am, is I'll need you to file a written answer with the court within the next, when's my next day? October 31st. You'll need to file a written answer to the court by October 30th, 2025. You need to provide a copy of that written answer to counsel. You need also to provide information as to where the rent is being held in escrow. I will reserve the issue of escrow for payment to the court for determination at the next proceeding. I'll adjourn this matter out to October 31st, 2025 at 12 noon. And ma'am, that's an in-person proceeding, so you'll need to be down at the courthouse.
Thank you, Your Honor.
All right, thank you.
Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good afternoon, Your Honor. Norman Whitty, appearing on behalf of the plaintiff, Cross Street Apartments.
Your name? All right. And folks, where are we on this case?
Your Honor, if the court recalls, we had a first hearing on this over Zoom, and Ms. Schumacher raised an issue with trash collection at her apartment. And I've had a chance to talk to her and talk to my client, so I thought I'd give the court a brief update as to what the issue is.
All right.
And how we're hoping to proceed. The problem is that these are second floor apartments in a two-story building, and the building's lot line is the building's perimeter. So there's no place to put external trash cans. Historically, there have been trash cans on the sidewalk. That's been the way it has been for years and years and years. Recently, the city of Ypsilanti's code compliance people have been ticketing and refusing to allow the trash cans there. There's no place else to put them.
So the city of Ipsy's been ticketing
the owner and tenants for having trash cans on the sidewalk. The problem is we can't put it inside the building. This is one of those buildings where you open up the door, there's a vestibule big enough for the door swing, and then there's a staircase going up to the apartments. So we can't put it inside. There's no place off street to put it because my client doesn't own any place off street. So I think Ms. Schumacher is very reasonably saying, I don't want to drive 45 minutes to my parents' house to get rid of my trash. And I don't have a problem with her escrowing the rent. I'm getting up to speed on this now. What I want to do now is go back and read the city's ordinance and talk to them about this problem and try to find a resolution. So I think the best thing to do would be to kick this back a couple weeks to give me an opportunity to sit and talk to the city and see if we can't find a solution that works for the city, for my client, and for Ms. Schumacher, who absolutely should have a way to get rid of her trash on site.
What do you want to tell me? Thank you, counsel, for that.
I mean, I agree with pushing it back until the issue gets.
So that is very strange to me because I don't think in all the years I've been doing this that not having a place to put your trash has ever been an issue.
New one for me too.
I just have not heard of that. And when you were telling me at the first hearing, I'm thinking to myself, okay, what's this lady talking about? Thank you for getting that clarified because I wasn't sure when you were saying about the trash issue, and then we got the documents, and I'm still trying to. I don't understand. Like you just have no other place to put it. So what have you been doing?
I've been driving it 45 miles one way to my parents' house to dispose of it properly.
That's not acceptable.
Bless your heart. Okay. Yeah, that's not. What other? Are there other buildings around that?
And that's actually another part of the problem. Is that there's another apartment building that my client doesn't own next door, and their tenants also tend to be putting things into any receptacles we have on the sidewalk. And so,
did they have the same issue, you think, or?
I'm not sure about that. It's too early for me to know that.
Gotcha.
But, from my standpoint, Your Honor, I totally understand where Ms. Schumacher's coming from. My client has been diligently trying to resolve the problem, but they haven't involved me. And as you know, attorneys have some other tools that maybe the manager doesn't have. So I'm hoping to sit down and see if I can't work a resolution of this.
And just one other question. So they've been ticketing the owner for the trash that's outside?
So for example, Jimmy John's is a tenant downstairs in the building, and they've historically had their trash cans outside for years and years. And now code compliance is saying you can't. So my client got a $200 ticket for Jimmy John's trash cans sitting outside.
Because Jimmy John's is a tenant of your client.
Correct.
Right.
My client represents the owner.
So, okay. I'm just going to ask this question out loud. I don't expect an answer because you probably, neither one of you probably know. How do you allow a restaurant to open without having looked at whether or not they have the ability to dispose of things? But you would have done that because that's the way they were doing it.
Well, so there's two answers. First of all, what Jimmy John's is doing now is they're keeping the trash cans inside and then putting it out around the collection times. But again, I mean, this building is an older building. It probably predates the code. My position is these are grandfathered uses because it's been done like this since the beginning of time. But saying that and having code compliance agree with me, there's a long path to walk between here and there.
Oh, have you dealt with the city?
No, I'm sure this is going to be fun.
It's a much longer walk than you probably are in.
We're going to find out.
Just going to say that. How much time do you think would be?
I'd like to kick it a couple weeks and then come back by Zoom. I don't want Ms. Schumacher to have to come forward on these things because I don't think we have any factual disagreement between us. We're not going to need a trial. We're just going to need to find a solution.
Okay. And I'm just saying, if for whatever reason you don't get to where you need to be, if somehow or another you interplead the city, then I could foresee a settlement conference with you representing your client, Ms. Schumacher, in the city. Because
Your Honor, that's
right. She should not have to be doing that.
No, not at all.
All right. So I have 7th, 14th, 21st. Well, it'll be right before Thanksgiving. So which would be better for you, man? Why don't we?
I'm sorry, what was the date?
The 7th, the 14th, and the 21st.
Of November.
If you watch more football, you'd be able to follow right along. But anyway, go ahead. 14th would be. I have the 21st.
That's fine, Your Honor. I don't expect the city to be moving at the speed of lightning either. So.
Your expectations will probably be well, never mind. I'll adjourn this to November 21st, 2025 at 3 p.m. That's an in-person hearing. However, what I will do is I will allow the parties to appear via Zoom given the circumstances.
Appreciate it very much, Your Honor.
All right. Anything else, Ms. Schumacher?
There will be no judgment.
There's
Ms. Schumacher, I do a lot of these hearings. Okay. Right now, don't you even worry about that. I think the ultimate issue is to try to figure out how to solve this problem for you. All right. I mean, certainly for the landlord, but really solve the problem for you. You shouldn't have to be doing what you're doing.
Just to give Ms. Schumacher a little bit of comfort on that issue. She's been very reasonable to work with. She's putting her money in escrow. I don't need an order for escrow. She's going to give me the information on that. And just so you understand, the most likely outcome, if we work this out, would be something called a conditional dismissal. And that would provide that you would then pay the rent because you're satisfied with the situation and the case is dismissed. So I don't see, based on what I know now, any point at which I'm going to ask the judge to enter a judgment against you. I mean, things could change, but I don't see.
And now knowing what I know, even if he asked.
Get it.
All right. Okay. Ms. Schumacher, thank you. You have a great weekend.
Thank you.
Pleasant Lake Park versus Christopher Denowitz.
Good afternoon, Judge. David Morris on behalf of Plaintiff Pleasant Lake Park, LLC.
Your name, sir?
Christopher Genoviak.
Okay.
Sorry about that. I'm a little hurt today. Had to step out of the hall. I'm a recipient of SSDI at 100% since March of 2020. I just got some things I want to read. I don't know how the protocol is around here, but I'm sure you'll tell me.
Well, it doesn't start with that.
Just start with this.
No, it doesn't.
I didn't hear you. I'm sorry.
It does not start that way.
Okay. All right, cool. Thanks for your time.
Judge, this is our second hearing on a non-payment of rent matter. Current rent to retain possession is $495 with fees of $75, costs of $110 for a total amount of $680. We have had some discussions, but no payments have been made, and parties were unsuccessful in finding settlement. I should note, Your Honor, that it appears an answer was filed with the court, but I did not receive a copy.
We'll get your copy.
Thank you.
All right, sir. What did you want to tell me?
Okay. So they're not doing maintenance to force the default. I've spoken with an attorney, like one of those free attorneys that you call them, a number they give you on the form. I called one of them. They're like, yeah, you have like a brilliant retaliatory defense. I guess he's trying to do default and to quit. I guess I got the notice.
Do what?
I guess I'll just read what I have. I'll read what I have.
Well, let's not.
I don't want to jump the gun here, but I did. This kind of makes more sense. So they're not doing maintenance to force the default. They did not board up holes, but they set traps and they put poison outside the unit, like when they should have just boarded up the holes. This creature, it's like a rodent. It's like nesting underneath my bedroom, like my bedroom floor. The skirting was never fully pulled back when he promised me that. We both saw this creature, and he set traps that were too small. And then he put poison outside the unit. He never pulled the skirting back to put poison on its nest. There are multiple entries around this unit. Let me continue. I'm really sorry for wasting your time. We really shouldn't be here.
Ma'am.
So the skirting.
Sir, you're not wasting my time. I'm getting paid.
Yes.
Go ahead.
Yes, sir. Well, I'm unemployed. I lost my job like a few weeks ago.
Okay. Go ahead with your. Go ahead.
I know.
Go ahead with your reading, please.
So the traps are too small. And Mr. Weasel, that's the name. That's the person trying to evict me right now. Is Mr. Weasel. Mr. Weasel and I both saw this rodent or creature, not at the same time, but it entered out of the lake. My rental unit is up against a small wooded line about 15 to 20 yards, and then there's a massive lake. So we both seen this creature. It is fat. It is large. It's like a gopher. It's like a beaver rodent creature. So there's 10 points. There's 10 points. Almost done. So the traps are too small. He put, and we both saw it. We both know it's big. So I was trying to do walkarounds, and Mr. Weasel usually just sends his maintenance dude just to do the maintenance. And this maintenance gentleman is a kind man. He also lives in the park. And this gentleman also works for Mr. Weasel at the landscaping company. And let me point, for Mr. Weasel to send out this maintenance dude, he has to pay him double time. So he's a maintenance. This man is an employee twice for Mr. Weasel. So we did schedule one walk around, but I was late returning from cleaning up a church festival. I spent 9 hours at a church festival on Monday morning. I was cleaning. We had.
So if they get rid of this
and I wanted to
animal, then
yes, sir.
we're all good.
We're all good. And let me just I have a couple more points. I know this is really going into banana town.
Do you know anything about the animal?
I did set up a trail cam.
Okay.
Okay,
sir.
But I don't want to use that. I need to finish my points. So he never contacted me. He was on the property twice doing maintenance that wasn't completed, and he never contacted me when I was in the house.
Sir, I'm going to stop you.
I know. I'm sorry. I'm going to
stop you. That means stop talking.
Yes, Judge.
Counsel, do you know anything about this animal?
We know of the idea of the animal.
Okay, I have no idea what that means.
We've heard of the issue, but my client has not set eyes on any animal. The animal at one time maybe was a mouse, and then a rat, and a cat, and then a beaver, and a badger. And so my client knows nothing about any real animal. Traps were set. The skirt was tightened on the manufactured home. He has been out, or his management has been out on multiple occasions and has responded to all legitimate requests. The defendant.
Sir, you need to turn around and face the front and not wander.
I understand the defendant set up trail cams. We've received no footage. We've received no recording. We've received no audio file, no video. the defendant claimed over the phone that there's hours of critter noise every night. There are neighbors to the defendant.
So, let me just stop you. Might it behoove your client to just,
Board up the holes that are super obvious. I'm sorry.
I don't know at
Read it
what
out.
point I said I needed help with my sentence.
I know, I'm sorry.
Then you need to sit down and be quiet. Be quiet then if you can't sit.
We're cool. Yeah, stand still. I know. I just gotta keep moving. I gotta keep moving. Sorry. I know. I'm sorry. I'm really sorry.
Might it behoove your client to just hire a company to come out and look and make a determination based upon evidence that they see as to whether or not this creature exists or not? Because quite frankly, if there's a company that goes out and they tell me, yes, there's an animal, then they can tell you how to eradicate it. If they say there's not an animal, we're going to be at a point that there's not an animal. And apparently not one that grows from a mouse to a beaver in no time at all. I've never heard of one in Michigan, but we'll see. All right. So how long, do you think your client would be interested in doing that, counsel?
Yes, Judge. I think my client would be happy to get an extermination company to come and write a report.
Just, yeah. How long do you think it would take him to do that? Because I can put this over to the 7th and 14th. What would you? And I'm going to order escrow. So.
Thank you, Judge. I think the 14th would be
a better thing.
Better.
What does that mean? What does order escrow?
So I'll explain that in a moment. I'm going to adjourn this to November 14th, 2025 at
2 p.m.
At 2 p.m. That will be an in-person hearing. How much is monthly rent? It's
monthly rent is $1,250, Your Honor.
But portion of it is paid.
Correct.
What's his portion? Do you have Section 8 or something like that, sir?
Just SSDI.
So you pay your full rent?
Yeah, I've got a job. I'm not employed now because of the noises underneath my bed every night for 3.5 months. Like I can't sleep. I can't
okay.
sleep.
Your monthly rent is how much?
$1,250, Judge.
$1,250. All right. I'm going to order escrow in the amount of $1,250. That is to be paid within 7 days of the date that it's ordinarily due. You have to, and what I mean by escrow, sir, is you need to bring escrow to the court as funds, pay them to the court until this is resolved. When you bring it to the court to pay, the $1,200 must be in cash. We do not take checks or other money. Understood?
Not understood. I have additional comments that I'm not sure if he just wants to evict me in the future again. But the bathroom floor is sinking by 1.5 inches. There's a hole in the bathroom floor sinking. There's I've already made this maintenance request. And actually, so there's an animal. I found this out about 2 nights ago because I had missing food. There's an animal entering my living room through the vent. This is a trailer from the 80s. So this past week I've had and I know exactly which vent it is. And I've complained about that. So there's now an animal entering my vent that I found out 2 days ago, and it's been eating my leftover food. It's going into my living room. This is a super old trailer, massive. There's holes all around. He's already boarded up 10 feet on the main stairs. He's boarded up 20 feet on the south side, and I'm asking for 8 to more 10 feet.
What is your next point?
So my next point is this trailer. I want to. So here's my official request, Judge. I want a state inspector. I want something from the state.
Then if you want a state inspector, you can call them and have it inspected.
Yeah, okay, super. And then I'll find out about this private inspector in the future. Is that what I should be expecting? Because I want a state inspector.
I'm not going to tell you to expect anything.
Okay,
you say you want it inspected.
I want an inspector. I want a state
whether or not somebody's going to inspect it. What's your next point?
My next point is a bathroom floor sinking. I think this unit should be condemned. It should be pulled off the property.
We all have our thoughts and our process. I don't know.
I'm going through that process right now. I'm just green thumb. So, but this unit needs.
Is there another point?
That was Judge. I appreciate your time.
Is that it?
Yes, Judge.
Thank you.
Judge.
Check the bathroom floor, please, counsel.
Yes, sir.
Check. Thank you, Judge. Thank you, Judge. Thank you for your service.
Chris, we'll be in touch about. We'll give you some notice before we go.
Don't, hey, come here. You walk out of here, you walk out of here with respect. Whether you like me or not, I don't care. You will not treat this courtroom that way. Am I understood?
Yes, Judge.
Now you may leave and you will leave in an orderly fashion. Go.
Yes, yes, Judge. I'm.
Go. Was that the end of that block? Thank God. All right, court can stand in recess. We'll be back unless somebody wants to go right now. Yep, didn't have any volunteers. All right, thank you.
Thanks, Judge.